Tonight, we are extremely pleased to be talking with Commander Kerchner and Attorney Apuzzo about the eligibility issue.
All right. Well, I don't have a speech planned or anything like that, but let me start out with the request for donations. People want to help the cause. We need help financially to keep the advertising going and in the print media to keep educating the public about the constitutional Article 2 term natural born citizen and what it really means. And they can go to the website at www.protectourliberty.org. That's protectourliberty.org. And they can see all the ads that we've run in the last year. It's about 2.5 dozen full-page ads in the Washington Times. And I think they've had a tremendous effect in publishing Mario's essays and other matters. There's also a link there to a new summary of the 12 counts in the complaint that I filed a year and 3 months ago. And that's kind of a nice thing to click on and print out to have in front of you. It shows the 12 counts of charges against Obama, Congress, and the other 5 defendants. We keep forgetting that Congress is also a defendant in my lawsuit. And there's a quo warranto action in there, and there's many, many other counts of violation of due process, violation of equal protection under the law because McCain was investigated and Obama wasn't. If you read the 12 counts, you'll see why this case is much, much different than any other case that's been brought to the court prior to this, including the Tomminess that was filed after the joint session of Congress when he was the illegal president-elect, but he was constitutionally confirmed by the Congress, but legally confirmed. But he was a president-elect, putative or de facto, and I sued before he was sworn in. So he was still, quote, a civilian, but he was obligated under the Constitution to be living up to the Constitution at that point. When he was not confirmed by Congress yet, he was still a candidate, and he could hide behind various laws. But as soon as he got confirmed by Congress, the onus was on him to prove he was eligible in that 2-week period, and he didn't. And he accepted being sworn in, and he violated the oath he took that day. So.
Very good. Commander, I think we have Attorney Apuzzo on. Is that correct?
Yes. Hi, Dr. Kate. It's me, Mario Apuzzo. Good evening, Charlie.
That's what that means.
Well, this is what it means. I received a letter from the court, and it's from the clerk's office, and it sets down Tuesday, June 29th, 2010 in Newark as a tentative date for a merits decision. Now, merits, it's a good thing that I just was reading my email, and we got an email from JJ. He posts on the blog as JJ, and he wanted to know whether does merits mean the underlying merits? Now, underlying meaning is Obama eligible or not, and that goes to the question of whether he's adequately proven that he's a baby, a person born in Hawaii, and of course the ultimate issue whether he's a natural-born citizen, which again it doesn't relate just to where he's born, but it goes to the definition of a natural-born citizen, which we've said many times that it's a child born to 2 citizen parents, child born in the country.
Yeah, we'd want to hear his argument as to why he thinks that doesn't apply to him. That's what we'd want to hear.
Yeah.
Why does he think that not having 2 parents as citizens somehow makes him a natural born anyway? That would be interesting to hear his argument.
Yes. Well, the hope is that we will get to a court that will decide that
right.
Those merits. Now, the district court in Camden that decided our case dismissed the case not on the underlying merits, but on a threshold issue of jurisdiction, which is standing, and political question. So the only issues that are on appeal are those issues, standing and political question. So when we talk about the merits, we're talking about the merits of those issues, not the underlying merits to whether or not Obama is a natural-born citizen, just so that's clear. Okay, so you could have different merits. You could have merits that are not necessarily the underlying merits, which is what is happening here. So on Tuesday, June the 29th, there's going to be this, tentatively, the panel would decide the case, tentatively. Now, they have a whole procedure how they do that. Just because that date is there doesn't mean they're going to render a decision on that particular day. Because then they go through this whole process where a judge is assigned the decision to write it, then it's distributed, the draft decision, to the other judges. Each judge can write a concurring or a dissenting opinion. Then the decision, which is a draft decision, goes around to different judges, to the presiding judge. They vote on it, they agree to it. Eventually, a decision is published. Now, the decision could be either presidential or non-presidential, which is important because when something is presidential, that means that a panel of the court cannot go against that presidential decision. Okay, so for example, we know that in the Third Circuit we have the case of Philip Berg, who everybody knows, an attorney who's filed the initial cases against Obama, although his only issue is whether or not Obama is born in America.
And he filed when Obama was a candidate, which makes a difference on rightness.
Yes, yeah, that's all explained in my brief, my reply brief, where I set out why Berg's case is different from ours. But the point that I'm making is that Berg's case is a presidential decision. So if the appeals court felt that decision controlled our case, if it felt that way, okay, then it can't go against that decision. The only way you can go against that decision is if you have a en banc proceeding, okay, which is basically the whole court.
You argued in the briefs that the case is not presidential.
Exactly. No, it is president. Well, let's just clarify that. It is presidential,
but not relevant to our case.
Right. It's not controlling of our case, even though it is a precedent. Because the decision itself says presidential. Okay.